Okay, welcome to our Beef Feed Yard webinar series. Hopefully, everybody's going we've had a challenging year and a lot of manure issues, and we thought this was a very timely topic. Our presenter today is Dr. Amy Smith. She's going to be talking about manure transfers, and particularly how that aligns with our record keeping and things that I think our feed yards need to know and track. So Amy, thanks for doing this and look forward to your comments.
All right, thank you, Galen. So I'm going to talk about manure transfers today, and the discussion that we'll have is based on permitted livestock operations. So those operations that have a state or NPDES operating permit and have reporting requirements under that permit. So three topics that I want to talk about. First is just what is the regulatory definition of manure transfer. Then we'll talk a little bit about the required records when a manure transfer is conducted. And then I've got some example scenarios that we can work through to kind of reinforce the process of thinking through whether or not a exchange of manure is considered a manure transfer by regulatory definition. So regulatory definition of manure transfer. Permitted CAFOs in Nebraska, they have to demonstrate that they have access to sufficient land to manage manure nitrogen that's produced on that operation. For some operations, they may own all of that land and obviously have free access to it. But if a producer does not have enough land of their own to utilize all of their manure, then they're going to be trying to find additional land where they can apply manure. And this might involve, for those folks, a spreading agreement of sorts for where a neighbor has agreed that for the next 5 years or however long that you write a contract for, that you'd be allowed access to their land to apply manure as part of your nutrient management plan. Or it could be marketing that manure and selling it to other individuals who want to use it. So if manure is transferred to a third party, whether it's purchased or given to that third party, and then that individual loads and hauls that manure off of the production site, then this is what would be considered a manure transfer. And then a record of that transfer would need to be kept. I've put a link on the screen here to some information on our UNL website about manure transfers, and there's a couple of forms there from the Nebraska Department of Environment and Energy that might be good references for planning and deciding if additional land is necessary and if manure transfers are necessary for your farm. So kind of the key point that I want to drive home is that determining whether or not the movement of manure is officially or by regulatory definition a transfer comes down to recognizing who has control of the manure. So in the scenarios that I'm going to share in a little bit here, we'll think about three different entities that could be involved. So the CAFO operator, that's the person who owns the livestock. They're listed on the permit, so they have initial possession of that manure as a product from their farm. The contractor may or may not be involved, but this would be like a custom manure hauler or just someone who helps either deliver manure to a site and or deliver and apply that manure off of the animal feeding operation. And then the farmer in this scenario is someone not associated with the animal feeding operation, and they're the person receiving the manure for use on their cropland. So I've got a couple of different scenarios here, I guess different combinations of how the manure and the land might be managed, and then who's applying that manure, and we'll talk through these to look at which ones qualify as a transfer and which don't. So the first scenario, if the CAFO operator is the person who owns the land that's receiving the manure, so they own the animals, they own the manure, and they own the land where that manure is being applied, this is a pretty straightforward situation. It's obviously not a transfer because it's not leaving that the ownership of that land animal feeding operation. In this case, that land should be in the operator's nutrient management plan. If it's not, and they're starting to use land that they own that was not previously listed in the plan, that would need to be included. There would need to be a revision of the plan to include that land. So in all of these other situations, the person who is receiving, the person who owns the land where that manure is being applied is the farmer. So it's the farmer with crops that's not associated with the livestock operation. So that farmer may own the land and have a spreading agreement with the CAFO operator, in which case the CAFO operator has that land in their nutrient management plan already. And so the CAFO operator is determining how and when and where and how much manure is applied to that land. So if that's the case, this would not be a transfer. Again, it's leaving the farm where it was produced, but it's not leaving the control of the CAFO operator. If instead we have a farmer who is using manure from a CAFO on their cropland, and they're not currently included in the nutrient management plan, or that land is not currently part of the livestock operations nutrient management plan, then we have a couple different scenarios we can think about. One is that the entity that's applying that manure is the farmer who's accepting it, or a contractor that's been hired by the farmer. So in that case, the CAFO operator technically has either sold or given that manure to the farmer or a contractor who has come and taken it from the CAFO operation, taken it to the farmer, and done the land application. So that would be a legitimate transfer of manure. So it's no longer in the possession or under the control of the CAFO operator. On the other hand, if there's land, perhaps a neighbor has land that you've never applied manure to before, but you need additional land this year. Maybe some of the other land that you've been using got taken out of your nutrient management plan, and a farmer says, sure, you can use these 200 acres and apply manure from your site. So in that case, that's not a transfer. Again, it is leaving the site where the manure was produced, but it's not leaving the control of the CAFO operator. The one thing that we need to keep in mind, though, is that that land would need to be added to the nutrient management plan through a modification of that nutrient management plan to be in compliance. So there's really only one situation here that was a legitimate transfer, and that is when the manure leaves the CAFO and the farmer who is accepting it, or a contractor that is working with that farmer, is the person who takes it and determines how it's applied to the land. So this is just kind of a manure transfer decision tree that I came up with, and I won't go through it because it's basically what we've just talked about, but kind of asks a set of questions that you can look through and answer yes or no, and get to the end and decide is this a transfer or is it not. So what's required as far as records for a manure transfer? Once you've decided that it's actually a legitimate transfer, the CAFO operator, the person who owns the animals and the manure, they're going to need to record in their record keeping system, first of all, the amount of manure, whether it's tons of feedlot manure or litter or gallons of slurry, whatever units that's in, they'll need to record how much was transferred. They need to record the date or dates in which that manure was transferred, who it went to, and the address of that person. And then the other thing they'll need to do is provide the recipient of the manure with an analysis of the material that they're taking. And although that person taking the manure is not they're not necessarily regulated under any permit on how they land apply it, so they don't necessarily have a nutrient management plan that dictates how they apply it, but they should have that analysis available so that they can make a decision that is agronomically suitable for where they're using the manure. For any other use of manure that's on land that's controlled by the CAFO operator, this is kind of just your usual record keeping for the CAFO. So these are acres that are included in your nutrient management plan, and you probably know the whole list of analyses and data that needs to be kept on those for those manure applications. Okay, so I have 4 situations here that we'll run through just to kind of reinforce some of the information that I just shared. So in this first situation, we have a farmer who loads, hauls, and applies manure from a CAFO onto his field, and that field is not part of the CAFO's nutrient management plan. So this would be considered a legitimate transfer. The reason we would consider it a transfer is that the CAFO operator no longer is controlling the manure or the land that's receiving it. So it has officially left his or her hands and is now decisions about how it's applied are being made by the farmer that has it. So keep in mind, this CAFO operator would need to record all the details of that transfer and give the farmer a copy of the analysis for that manure. So in our second situation, a CAFO operator loads, hauls, and spreads manure on a farmer's field that is not part of the CAFO's nutrient management plan. So this is not a transfer. The CAFO operator is still controlling where and when and how that manure is applied. But what we need to keep in mind in this situation is that all of the land that CAFO operator applies manure to needs to be part of their nutrient management plan. So they'll need to do a modification of their plan to include that land so that they're not in violation of their CAFO permit. So the third situation, a contractor loads and hauls manure from a CAFO to a farmer's field that is not part of the CAFO's nutrient management plan, and then the farmer applies the manure. So this would be considered a legitimate transfer. Again, the CAFO operator no longer has control of the manure or land receiving it. One thing I didn't say in this situation, if that contractor is loading and hauling manure, it basically has been hired by the farmer to get this much manure from this CAFO and bring it to his farm, stockpile it on the edge of the field, and then the farmer will land apply it. That would be a transfer because it's under the direction of the farmer. If the CAFO operator tells the farmer, I need this many loads taken to this site and applied at this rate, then again, that's still a situation where the CAFO operator is making those decisions, so it would not be considered a transfer. Again, for this particular situation, CAFO operator needs to record all the details of that transfer and share the nutrient analysis with the contractor and then have that passed along to the farmer. So the last one here, a farmer receives stockpiled feedlot manure or poultry litter for a field that's not part of the CAFO's nutrient management plan, and the stockpile remains at the site for 2 years. So this is kind of a unique situation. We have manure being moved and we have manure being left stockpiled at the site of the field for a while. So first of all, it's a legitimate transfer. The farmer received that manure. He or she requested X number of tons placed at the edge of their field with the intent that when crops were harvested, that manure would be spread. So the CAFO operator doesn't have control of the manure or the land that's receiving it, so that is a transfer. The thing that we need to think about in this case, though, in the state of Nebraska, the regulations state that manure should be spread within 12 months. And so if this person has left that stockpile there for 2 years, that's probably not a great idea. Again, that person's not operating under a permit, so it's, the CAFO operator is regulated a bit more in how they handle that. But the farmer, if the DEQ or NDEE, they are now, if they were to see that or somebody reported it and they decided that was a water quality risk, then they're going to want something done with that manure to eliminate that water quality risk. And at that point, it kind of becomes a question of who's responsible for where that manure was placed. So I don't know any definite situations that have occurred where the farmer was held accountable and or the CAFO operator was held accountable. But the point is, when the CAFO operator delivers that or has it delivered by a contractor, they should keep in mind kind of the basic rules of storing that manure so that it's not a water quality risk. So if there needs to be a berm around it to control runoff, if it's, needs to be placed far away from a tile inlet or waterway or property lines. So just kind of common sense ways that we need to think about placing that manure on the side of the field. So that one is kind of a unique situation, and I bring it up just because the liability of the CAFO operator lies in the beginning of that situation when they help advise that farmer on how to stockpile or where to stockpile the manure. So just a summary, the key to defining whether a manure is legitimately transferred is determining who maintains control of the manure. If it's not a legitimate transfer, then the CAFO operator is going to go ahead and record all of the normal records that they would about where it was applied and what the weather conditions were and how it was applied. If it is a legitimate transfer, then the CAFO operator needs to supply the recipient with a manure analysis, and then they need to record all of the relevant details of that transfer. So if you're in doubt, it's always best to ask the NDEE. They're certainly there to help and to help you determine whether this is your record keeping or whether this is your control of manure or someone else's, and so that you record that correctly. So reaching out to the NDEE is definitely recommended if you're unsure in any particular situation. So that's all I have. I've got my email address and phone number up here if anyone wants to reach out with additional questions, and then just a couple of our other resources from the animal manure management team, our manure website, and ag site planner tool. So thank you very much.
Very good, Amy. May I ask a question? Obviously, from a record keeping standpoint, this incentivizes some transfer of manure, and I understand the interest. Plus, it's good to transfer manure nutrients to acres that need those. But one of my questions is related to most acres are probably that are close to a CAFO, in this case, let's say a beef feed yard. They're probably already in the nutrient management plan because they're either controlled by the CAFO or maybe were necessary to develop the nutrient management plan at the beginning. Does that make sense? So
Yep.
it seems like one of the challenges that I think this record keeping requirement results in is that actually the transfer to manure increases the hauling distance. Does that my question make sense? Because you're probably
Right.
transferring people that are a lot further out.
Sure. So it definitely could be a situation where you're having to go farther from your site than you normally do. I do hear, crop producers who say, I'd like to get manure, but I don't know where to get it. And then they have a farmer less than a mile away that has manure that they want to get rid of. So I think there definitely are still such situations where that would not be a long distance transfer of manure if those two were to connect. But I think you're right that in most cases, that CAFO operator has utilized land according to how far it is from their operation. And if they're going farther out, that means they need additional land that's not available. And that does include or does increase the hauling costs for it.
Very good. Thank you.
Mm-hmm.